that. Get comfortable. If you have any questions, we'll be here.
Yeah, that sounds good, thank you.
Thank you. Appreciate it.
So we are not keeping it on the stream.
Yeah.
Continue, you don't want to worry.
Let's get this started. We are testing Judge Microphone 1. Judge Mic 2. Let's turn that up. Okay. Time there. All right, one more time. Judge Mic 2. Much better. Judge Mic 3. Oh, that doesn't sound bad. Okay. Judge Mic 4. Judge Mic 5. Judge Mic 6. And Judge Mic 7. Ooh.
Turning your, yeah, I'll turn that down.
Thank you, yeah.
Also turning your main down. And, oh, they have.
Yeah, yeah, yeah.
I think that'll be all set.
Cool. Yeah, not bad. Sounds too bad. All right. Honorable Justices of the Supreme Judicial Court, sitting at the Law Court at Portland, within the state of Maine, may come forth and declare, and they shall be heard.
Good morning. You can be seated. The first matter before the court is Somerset 25-264, Beem versus Temple. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. And counsel, I would ask that you first identify yourselves by saying your names for the record together with the party you represent.
Charlie King here with my partner Tim Kenlin. We're here for appellant Amy Beem.
Sam Johnson, Your Honor, and I represent the appellee Nancy Temple.
Thank you. Attorney King, if you're ready to proceed, we'd be happy to hear your argument this morning.
Good morning, Your Honors, and may it please the court. The trial court erred when it applied the equine activity statute to effectively create two different categories of potentially immune defendants, with equine participants on one hand and any person not engaged in an equine activity on the other. The problem is the court applied the statutory exceptions to immunity only to equine participants, leaving the immunity for non-participants completely undisturbed. So ironically, even though this statute was designed to create greater protections from liability for equine participants, under the trial court's ruling, equine participants actually have fewer protections than everyone else. As it stands, the defendant in this case is completely immune from liability because she wasn't riding a horse when she caused my client's mule to bolt. And that's regardless of whether she acted negligently or recklessly or even intentionally. She could have been driving 100 miles an hour down that road and exploded in a fireball behind the mule, and she would still not be liable because her immunity is absolute. That cannot be correct. It's an absurd result that needs to be avoided. And as we see it, the court has two paths that it can take. It can either avoid the absurd result by applying the statutory exceptions to immunity to both non-participants and participants alike, so that non-participants, like the defendant, can still be held liable for reckless or intentional behavior. Or, and we think this is the correct answer, the court can interpret the statute under the established doctrine of iusdem generis, the specific over the general, to hold that equine immunity applies only to equine participants, professionals, and sponsors, just like it says in the first sentence of the statute. In either case, the trial court erred when it held that the statute was unambiguous and that immunity applies in this case without any exceptions. Either immunity does not apply because the defendant is not an equine participant, or immunity applies but subject to the exceptions of reckless or intentional behavior. We therefore ask the court respectfully to reverse summary judgment and instruct the trial court to either proceed to trial because the defendant is not immune, or to, failing that, to instruct the trial court to determine whether there is sufficient evidence of the defendant's recklessness to put that issue before a jury. And with that, I'm happy to answer any questions.
Well, I'm looking at the language of the second sentence of 4103A1. A person may not make any claim or recover from any person for any property damage or damages for personal injury or death resulting from the inherent risks of equine activities. What's ambiguous about that sentence?
I
It may
think
not
that-
be, it's a policy choice. I'm not saying, the legislature, if they make a policy choice, why does that not sentence simply say, no one can recover for claims resulting from the inherent risks of equine activities?
Well, at the risk of using legalese, I think that it renders the first sentence of the statute mere surplusage. I don't understand why you would specifically delineate a categories of equine sponsors, participants, and professionals as being immune from liability, and in the very next sentence say everybody else is also immune from liability too. I think that those two sentences need to be read in concert to give effect to each other. If you only read the second sentence and apply it as written, the first sentence is meaningless.
So you're saying that under the literal language, that's one thing, but we can't read this statute literally because it results in absurdity?
Yes, Your Honor.
Well, it's not really absurd. It's just making, there's broad immunity, and one you can read as being a subset of that immunity, right? So is that really absurd? It may be surplusage, but is it absurd?
Well, given the ambiguity that I believe those two sentences create within the statute, and looking at the intention of the legislature when it drafted the statute, as the court already examined in McCandless, I think that the result of elevating the protections for the general public over equine participants and professionals under the statute doesn't make any sense given what the legislature was intending when it drafted it.
How would you then rewrite the second sentence to be consistent with your position?
With my position, I would say that that any person would have to mean any person engaged in an equine activity.
But the plaintiff in this case was engaged in a...
The defendant was not, though, and
So you're
that's the
saying
problem.
both the person, from any person not engaged in equine activity? Even though, so assume that's in there, it still says you can't recover for personal injury or death resulting from the inherent risks of...
Well, that's not, I don't think that that's the case, Your Honor, because even though the first sentence says that you can't recover from those entities due to injuries from the inherent risks of an equine, but those are all subject to the exceptions of reckless and intentional behavior.
Okay.
So the statute contemplates the fact that recovery due to equine behavior is possible under those exceptions. But I think that the first sentence shows that the legislature intended that immunity to apply
I
only to those
understand
categories.
how it does seem, what the argument about it seems like it may render the first sentence somewhat, I'm not sure it renders it completely surplusage, but I understand what you're saying. But what I don't understand is how you can read the sentence to say what you're saying. In other words, so you say that the any person, recover from any person, if you limit that to somebody who's not engaged in equine activities, okay? That's what you're saying?
No, Your Honor. I'm saying that any person, I'm saying that the any person needs to include only people who are engaged in equine activities.
Okay.
And that would mean that the immunity does not apply to those who are not engaged in equine activities.
Can I ask you, the inherent risks of equine activities, do you contend that that's a question of fact or law, or mixed?
I mean, I think that it's mixed. Obviously, there are risks of a horse bolting because there's a snake in the grass or something like that, but as far as risks of somebody's reckless or even intentional behavior, if I were to go to the Freiburg Fair and throw firecrackers under the Clydesdales and they stampede and trample over people, under the trial court's holding, I couldn't be sued for that.
So is it your position that if there's something sort of external to what would typically be part of equine activities, it's not an inherent risk?
I think that that's
Or is
a
that
way to look
question
at
for the
it.
jury?
Yeah, I think that's a question for the jury to determine whether somebody was, if we get that far, whether the activity that created the horse to bolt or the mule to trample or whatever was something that was due to reckless or intentional behavior, at least under the
Well,
exceptions.
even without
as
that,
written.
isn't there maybe a question of proximate cause? In other words, whether the injury is in fact resulting from the inherent risk, or is it resulting from, even though maybe she ultimately fell from the horse, is it caused by something in addition to or other than the
Right,
inherent risk?
that's right, and I
So
think
then that becomes a question of proximate cause, not a question of who or changing the language of the statute.
well, I think the problem is that, you know,
I'm throwing
it's-
you a lifeline.
I think you're right that is a problem of proximate cause. Especially because an intervening or superseding cause is usually something that is not foreseeable, and it is definitely foreseeable for equines to act as the way that they do. in
Well, but it
response
may
to
not be
things.
intervening or superseding, it may be concurrent.
Right, exactly.
And then what do you do with that under the statute is my question.
With respect
Does
to...
it make it a jury question is
Yes.
sort of the question, right?
Exactly.
If, in other words, if the horse behaves in a way that is listed under the inherent risks, but does so on account of specifically other behavior.
Correct, yeah, that should, I think that would need to be a jury issue, whether something resulted from an inherent risk. If it's an inherent risk of a horse shying from a loud bang from some car backfiring, or whether it's, somebody totaling their car right next to it. There are differences.
So based on the theories you've advanced so far this morning, some that have been tossed your way, what's your best argument at this point as to why the underlying grant of summary judgment should be reversed?
My underlying argument is that the statute is ambiguous because of the reasons that I've already talked about. But the fact that any person, if you use the, again...
Well, let me just ask you, okay, it is ambiguous, so then we get to look at legislative history, correct?
Correct.
Is there anything there that helps your argument?
Absolutely. Under McCandless, the court found that the purpose behind it was really sponsored by, horse owners, horse renters, people who were involved in the horse industry, and it was created to avoid skyrocketing insurance costs so they wouldn't have to worry about liability. But it certainly was not designed to afford unlimited immunity to random third parties who weren't even involved in horsing at all.
And again, just to go back, the ambiguity here is between trying to read together in Section 1, Sentence 1 and Sentence 2, and make them make sense.
Exactly, Your Honor.
What are we to do with the difference in sentence 1 says property damage or damages arising from injury or death, and the second sentence says injury or death resulting from the inherent risks? I mean, they seem to, the language about arising from injury or death resulting from inherent risks seems to be broader than simply resulting from. Arising from seems, I'm just saying, I don't know the answer to this. I'm
Right.
just wondering, I mean, it seems to me arising from seems to have a broader sort of related to, whereas resulting from is approximate cause.
I think that's obviously a possible answer, but I think that's another reason why these two sentences are difficult to read together in a concert.
Okay, thank you. Attorney Johnson.
Good morning, Your Honor. May it please the court. My name is Sam Johnson. I have the pleasure of representing Nancy Temple in this appeal. Although the facts of this case may seem like they arise out of a law school fact pattern or test, and that it involves a UTV, a mule, and a horse, what's really at issue is whether the appellant who was injured while engaged in an equine activity as a result of an inherent risk of that activity.
But what does subsection, I see that the green light is on. What does the second sentence add to the first sentence?
The second
The first
sentence...
sentence says that no one, essentially neither a sponsor, a professional, or anyone engaged in equine activity can be held liable from injuries resulting from the inherent risks. And then the second sentence says, and no one can make a claim against anyone for injuries. Why do you need the first sentence if the second sentence is what you say it is?
Well, the first sentence pertains to liability for damages resulting from. The second sentence, which is much broader, is the ability to make a claim as an injury resulting from an inherent
Right, but
risk.
the first sentence says no one can be held, a certain classification of people cannot be held liable from injuries resulting from the inherent risks. Why do you need that first sentence if the second sentence is, and by the way, no one can make a claim for those injuries, why, against anyone?
And again, Your Honor, it's meant to broaden the immunity provided by the statute. I think.
So the first sentence is surplusage. I guess, let me ask it a different way. Does the second sentence, or does the first sentence in the statute add anything or protect anyone that wouldn't be protected under the second sentence?
So the first sentence, again, if I'm understanding your question correctly, pertains to liability. So a
Correct.
person cannot be liable. The second defines when someone can, or when someone cannot, when it's inappropriate to bring a claim to recover for those injuries. So liability for the injuries or damages arising from an equine activity for equine participants. The second sentence broadens that, and I think there's a citation in the committee notes to a specific discussion and consideration of this is what the statutory language used to say, and it did apply to equine professionals and equine participants. The committee specifically considered whether the addition of any person, which would broaden the coverage afforded by the statute, should be included. And I think because that was expressly considered and discussed, and it made its way into the statute, it was intended to be in there to broaden the coverage.
So I understand that your argument is that they intended to have the broad, protections essentially from the inherent risks of equine activities that the second sentence appears to contain. But my question is a little different. Is there anything in the first sentence that is protected? Any claim? Is there anything under there that would not already be subsumed into the second sentence? Does it add anything?
And again, I apologize if I'm being repetitive. I think that pertains to who can be liable. The second sentence pertains to who can.
But nobody can be liable if one can't make a claim.
Yes, I understand that.
Let me, if I can come at this from a slightly different perspective. You're resorting to legislative history. Do you agree that the statute is somewhat ambiguous?
I do not, Your Honor.
Do we need to resort to the history in order to clarify this?
I do not believe that you need to resort to legislative history or legislative intent. I think the statutory language is pretty clear on its face. The key terms of the statute are defined. I had simply addressed the legislative history to the extent that it did become relevant, but our position is that it is not.
So you started out your argument by reference to a classic law school test. This is a classic case of a tort, isn't it? Common law negligence tort. Don't we construe statutes very strictly to the extent that they intend to narrow or preempt the common law? And shouldn't we take that approach here, especially if there's any question about how those first two sentences jive together?
I believe even with a narrow interpretation, Your Honor, it's still very clear based on the plain language that this is the situation that is meant to be preempted by this statute.
Can I ask you then a hypothetical or something about the consequences of your plain language interpretation? So, because there's this exception in subsection 2 for reckless or intentional conduct, which the plaintiff has referenced. So if you have a riding coach who intentionally walks by a child on a horse and does something to scare the horse for whatever reason, the horse bolts, that riding coach is not immune under the statute. Is that true? Do you agree with that?
Because they're engaged in an equine activity.
Right,
Yes.
so they fall within the subsection 2 exception. All right, so then you have the same scenario, child on a horse, but it's not a riding coach. It's a stranger walks in off the street to the arena for whatever reason, intentionally does something to scare the horse bolts, the child falls and is injured. That stranger, under your interpretation, is immune from suit?
Under the statutory language, yes. I guess I would couch that hypothetical with it's not exactly what we have in this case. But
I understand that, but
That's
is
why it's a
that not an
hypothetical.
absurd or illogical result?
It is, again, based on the plain language, that is exactly the result that is intended. And although we don't need to look at the legislative and committee notes, that is expressly contemplated. There was testimony from the equine community that if you spend time around horses, like there's going to be shying, kicking, bucking, you're going to fall off. It's not a matter of if.
We understand that, but why would it make any sense for them to say that if the riding instructor intentionally scares the horse, they can be held liable, but if some stranger who's not engaged in an equine activity comes up and intentionally scares the horse, they're immune. Why would that make any sense?
And again, Your Honor, it's based on what we have from the legislative committee, based on the plain language of the
The
statute.
legislative committee said that that was what they intended.
It was intended to bar claims for people that are engaged in an equine activity that are injured as inherent risk, which is if a equine becomes...
But they made an exception for intentional or reckless activity, reckless disregard, if it's a person who is in the business, but not if it's a stranger. Why does that make sense? I don't think that's addressed in the legislative history.
Only to the extent that they specifically considered adding any other person to broaden the initial coverage, and they didn't add it in the second portion. And
You could sort of see this as sort of analogous to a ski lift, or ski operation. If a person goes skiing, you're assuming the risk of injury, potentially regardless of how it happens. And same maybe in this hypothetical. You are riding a horse, you know it's a dangerous activity, so forth. But we're not talking about, in this case, someone who went to a riding facility. We're talking about someone who was on a trail and whose horse was spooked by a vehicle. Now, if that vehicle had struck the horse or nipped the horse and the horse reacted, is there immunity?
not in that situation, Your Honor. I think
Suppose the vehicle stops immediately short of the horse and the horse bucks. Immunity?
there would be in that situation.
Now, how is that any different than the first hypothetical?
Because being struck by a vehicle is not an inherent risk of engaging in an equine activity. You assume the risk that your horse, which is a prey animal, may become spooked, it may bolt, may hear a noise. It's the same thing.
The inherent risk is a collision with other objects.
And again, not the facts of this case, so not addressed, but that would go to the legislative intent and the plain language of the statute, which
Is
is
that
very
a
broad
question of
immunity.
fact or law, whether it's an inherent risk?
I believe it's a legal question, Your Honor, but to the extent that the court were to determine it was a fact question, the facts necessary for this were not disputed on summary judgment. Ms. Beem was engaged in an equine activity, riding her mule, and she...
Right, but my question is it your view that every time a horse bolts or spooks or bucks or whatever it does, whatever causes it, it's always going to be an inherent risk of equine activity?
To the extent that that it falls within the definition. And again, the definitions are very broad, like the unpredictability of an equine's reaction to sound, unfamiliar objects, movements. So in Justice Douglas' example, if you stop short and the horse reacts, that's either a reaction to sound, a sudden movement, or an unfamiliar object, which falls squarely within the statute.
But does it? I mean, and that brings me back to the question I asked your Attorney King, which is, isn't the proximate cause issue, i.e. resulting, is that a fact question? In other words, is the statute really so broad as to say, no matter what caused it, no matter how we got here, if ultimately someone falls off a horse, that's barred?
Under the statute, yes. If you are bringing a suit for an injury sustained falling off a horse when
But
that
it says resulting from the inherent risk. It doesn't say from, so isn't there a proximate cause issue, and isn't that really prototypically a fact question?
Again, in this case, the allegation that Ms. Beem was injured when she fell from her horse was not disputed. There was...
Well, I understand, but isn't the fact question of why she fell from her horse?
In certain situations it may be, but again, here the allegation was that the horse was spooked, the horse ran, and she fell from the horse at that point. So
And you're saying it doesn't matter why?
No, Your Honor. It does not matter why under the, again, plain language of the statute and the undisputed facts that were before the trial court.
No matter how many other causes there are, ultimately, if the injury results from a fall, the actual injury-producing mechanism is when you fall from the horse, no matter why that occurred.
Under the language of the statute, yes. I think the next step in that equation is if the statute were inapplicable, obviously the proximate cause issues is slightly different in that, here there was testimony that Ms. Beem passed out and fell off the horse at some point after. So I think that in a negligence context, that brings in the Addy, Jenkins, Hood line of cases where there would need to be something that the horse bucked and hit her chin and knocked her out and she fell off, or something specifically tying it to the UTV crash. But under this language of this statute is if you are bringing a suit for injury sustained when you fell off a horse that resulted from an inherent risk of riding that horse, those claims are barred under the plain
Wasn't
language.
so that the central question as to whether or not the fall was the result of something that was inherent to riding the horse? And isn't that the proximate cause question, and isn't that a factual question?
Your Honor, so again, based on the plain language of the statute, engaged in an equine activity not disputed in this case, injured, falling off the horse not disputed in this case, both of which are defined by statute as this is a equine activity, this is an inherent risk of that activity if you're injured falling from a horse while engaged in an equine activity.
If somebody had a crash, I don't know, did something, and so an object flew up and hit a horse, somebody was riding a horse, and as a result of being hit by that, so I'm trying to take it out of intentional conduct, obviously, but, and as a result of being hit by that object, the person falls off a horse, is that inherent risk?
Not in that situation.
Why?
Because it was being struck by an object is not an inherent risk of engaging in an equine activity. I think that's where the line, as the statute is written, is drawn, is if it,
Well, if you're riding the horse next to a road and the truck goes by and something's not sufficiently secure on the truck, falls off, hits the rider falls off. Is that inherent to engaging in equine activity?
Again, I think the introduction of an actual physical object striking the horse or the rider removes that from what is defined by statute unambiguously as the
So if the object strikes the horse and the horse bolts and then the person falls off, immune or not immune?
That would be, I believe, based on the language of the statute, that would be, there would be no immunity because the horse or the rider being struck by something is not an inherent risk of it's sounds, it's sights, it's unfamiliar object. Well, let me back that up. Subsection C, or D rather, does say collisions with other equines and objects. So in theory, there's an argument that the statute would apply in situations where an object strikes the rider. Again, I know we're talking hypothetically, and this is not the fact pattern we have here, but again, based on the plain language of the statute,
it could then come down to a factual question as to what actually caused the rider to fall off the horse. Was it the horse's reaction? Was it this being struck by an object? I mean, doesn't that go to the jury?
In certain cases, Your Honor, it could, but again, the trial court had undisputed facts in the summary judgment record that established what the cause was here. So for this case, certainly the facts that were pertinent to the decision and application of the statute were not disputed. It's possible that there may be cases.
Well, did the trial court actually address the issue? I mean, the trial court certainly said, she fell off the horse, but and classified that as an inherent risk. But did the trial court address the proximate cause issue of whether the reason why, the horse was bolting and she fell off?
So, yes, the facts, Your Honor, were the UTV crash never struck.
I understand.
And then as a result of that crash, proximate cause, the horse bolted. As a result of the horse bolting, at some point, Miss Beem fell off and was injured. Her lawsuit is seeking damages for the injuries that resulted from falling off the horse, which is an inherent risk, while engaged in that equine activity.
Thank you.
Thank you.
And Attorney King, I believe you reserved 3 minutes for rebuttal.
That's correct, Your Honor. I think many of the questions that were being put to opposing counsel really show why this statute, I think, can work much better if the exceptions to immunity applied to all persons instead of equine participants.
Yeah, but we can't rewrite the statute. I mean,
You
that's
can't
the
rewrite the statute, of
legislative
course not.
function.
You cannot. But the court does have a duty to interpret statutes in a way that does not lead to absurd results. And I think we've discussed a lot of absurd results.
But you're asking us to ignore a lot of the language that's in this statute.
I think that I'm only, what I'm trying to do is asking you, I mean, the second sentence, yes. I think that the second
I
sentence
just
should
don't
be.
see how you're asking us to do anything other than rewrite part of the statute, I guess is what I'm saying. It's not like there's a word that could be interpreted more than one way. I mean, you're essentially asking us to add language.
Well, I think what I'm asking you to do is, ideally, if I had my druthers, the first sentence under the, with the specific governing the general, the first sentence is specific identification of the categories of people to whom immunity applies, should be transported into this any person language in the second sentence. I think that any person engaged in an equine activity is the clearest way to interpret that second sentence and give effect to the intention of the legislature.
There don't appear to be a... oh,
Just
go ahead.
one more point. I'm looking at subsection 2, which is exceptions, participants. In the first clause of that sentence, it says, nothing in subsection 1 prevents, limits, or limits the liability of an equine activity sponsor, equine professional, or any other person engaged in an equine activity. And then the second sentence starts to repeat that. If the equine activity sponsor, equine professional, and then it just says, or person. Isn't that somewhat consistent with your argument that there's some words left out there, that that last reference to person really reflects back to the earlier language, person engaged in an equine activity, in that same sentence?
Your Honor, I think that, yeah, that is certainly a way that exception could be interpreted, with just using person instead of person or participant. I think that the court could look at that language and say that the exception applies to all persons instead of just one category.
Thank you. Thank you, counsel. As it is our ordinary practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter.